Okay, item 7, review and discuss Blue Cross Blue Shield billing issues, possible client representation agreement with Mr. Bryan Blevins, who's here with us, representing ProvstUmphrey Law Firm.
And I'll just say this is kind of a follow-up to the meeting we had with Kevin Reed regarding our issues with Blue Cross. Ron and Michael and I visited with Mr. Blevins in Austin a couple 3 weeks ago, and thought that it'd best, and then kind of at y'all's request, that he come here and just have a face-to-face meeting with us. Let us tell him a little about him and his firm, and also about his, I guess, his experience and kind of expectations of where we are with Blue Cross. But I'll just turn it over to you, Brian.
I hope y'all mind if I stand. I normally talk standing up, so I'm much more comfortable that way. I am Bryan Blevins, and I am a partner with ProvstUmphrey Law Firm out of Beaumont, Texas. I've been a partner since 1997. I've been with them since 1990 when I graduated from Baylor Law School. Our firm is a mixed contingency fee practice firm. That means we don't bill by the hour. We represent people on contingency fee, a percentage of the recovery, which also means that we arrange for the expenses of the case. We carry those, whether it's through direct spending or through finance spending, and then we only get paid if we make a successful recovery at the end of the case. And that includes both our time and our expenses. With respect to my personal practice, our firm has historically been a personal injury firm. We didn't do medical malpractice, just so we're clear on that. But we did do a wide variety of personal injury, particularly out of chemical plants and refineries in Southeast Texas. I did a lot of asbestos and silica litigation when I was first involved in our firm. But over the years, we have branched out into a number of other areas of litigation. I do some oil and gas, royalty owner litigation. I do BP spill litigation back in 2010. And prompt pay, and I'm happy to answer any questions about me or the firm. We've been doing what we've been doing. This is our 50th anniversary since our founder, Walter Humphrey, started the firm. We were one of the 5 firms that represented the state of Texas in the tobacco litigation. So that's sort of the snapshot of who we are. Our introduction into prompt pay was sort of by happenstance. As many of you may be familiar, the legislature passed the current prompt pay laws in 2003. They were originally passed in 2001, but then Governor Perry vetoed them. And then they came back in 2003, passed them again, and they became law. There was a gentleman, lawyer by the name of John O'Quinn, who had been very instrumental in promoting those laws, worked very closely with TMA and THA to get those laws passed. He was a plaintiff's lawyer, another one of the big 5 tobacco attorneys. John really invested a lot of money, time, and resources into building a clientele of prompt pay cases, particularly representing doctor groups, predominantly against the payors. But he met a tragic end in an automobile accident in roughly 2009, 2008. We, having had past relationships with his firm, reached out and basically took over his prompt pay docket. And the group and the expert and the data management of that from his offices, and we cleaned up basically all of his cases, and then we went on, once we had gained that expertise, to take on our own clients. We did that until probably about 2015. I was predominantly the person in charge of that. We represented almost exclusively doctor-provider groups, very few hospitals and clinics. And that's why we started to make the decision to leave the prompt pay area. Because, as I won't be a surprise to anybody in this room, doctor groups, no matter how large they are, tend to have disorganized back office practices. And they have lots of claims for lots of little services that all get stuck on one bill and are all subject to a variety of adjudication rules, many of which are not even appreciated. It is an incredibly data-intensive, trying effort to try to represent a medium to large size provider group in prompt pay. And then, as we were sort of looking at that, the Memorial Hospital, UHC, and Blue Cross Blue Shield cases sort of ended our interest in prompt pay, which might you now wonder why I'm standing here, which was, if you're not familiar with the case, it basically, the Fifth Circuit ruled a question that had been sort of on everyone's mind, and that was whether or not these prompt pay laws applied to claims that arose out of self-funded plans governed by ERISA, as opposed to a fully insured plan claim where Blue Cross Blue Shield or United Healthcare was the actual insurer, payor of that claim, versus an administrator of ERISA plans. That was an undetermined issue. I'm probably about as familiar with the legislative history because I made this argument many, many times in arbitrations, and we were winning that argument that in fact the prompt pay laws applied to those claims, those self-funded claims, probably about 65% of the time, 65 to 70. But when United Healthcare Memorial cases came out, the Fifth Circuit said, nope, bam. The prompt pay laws of Texas only apply to fully insured claims, period. And that's a real problem because 80 to 90% of most of the claims we were seeing in provider groups were self-funded. And without the benefit of the prompt pay laws, they have a really big, they're right back where they were pre-2000. And your case is an excellent example of that. And what I mean by that is whatever Blue Cross Blue Shield's complaints are, whatever they think was being done wrong, whatever they think the legal defenses are to what they've done, I don't care, because that's not how the prompt pay laws are written. You have basically 4 choices. You have, assuming it's an electronic claim, you have 30 days to pay the claim. You have 30 days to pay a portion of the claim and explain in detail in writing why you're not paying the rest of the claim. Or you have 30 days to tell the provider that you're not going to pay anything and exactly why in writing. Or the fourth one is you can pay 100% of the contract charge and then tell the provider, the hospital, that you're under audit. Now based on, and I'm much more familiar with the Knox group than I am with the facts of your case, to be honest with you, because they contracted with me first and I've gotten more information on that. But from what I understand from that, that isn't what Blue Cross Blue Shield did. They didn't pay claims. They didn't tell you why they weren't paying claims. They sat on that. They probably initiated a prepayment review, which is a neatly worded concept that you can't find anywhere. It's not even in your contract. There's no such thing as a prepayment review in your contract. And it's certainly not in the prompt pay laws. And the prompt pay laws have a wonderful provision that we won 100% of the time. And that is that every one of the primary sections of 1301 and the other one for HMO is 847, I think, have provisions that say you cannot enter into a contract that writes around or nullifies or voids the provisions of the prompt pay law. It does not matter under your contract that it says you have to do this, and you have to do that, and you have to go to mediation first, and you have to appeal. And it doesn't matter. None of those things matter. Because the prompt pay laws say you have this long to pay the claim, and if you don't, then you have to do these 3 things. And if you don't do those 3 things, you are the one who is at fault. And all those other contract provisions are about avoiding that very limited set of options. It's a great law. It is, in 2015, I was the president of the Texas Trial Lawyers Association, which in a legislative session year means that in effect I'm an unpaid lobbyist. I'm across the street at the Capitol on behalf of families of the state of Texas trying to prevent them from writing more bad laws that do nothing but hurt individuals. And so one of the laws came up. Blue Cross Blue Shield started to put on a big push to roll back the prompt pay laws. Prompt pay law penalties are the most aggressive of any prompt pay laws anywhere in the country. Every state in the union has prompt pay laws of some kind. Texas's are by far the most robust. They are In the right case, they are crippling. Y'all's case is probably not going to quite be that, because one of the key elements of the penalty structure is the difference between the billed charge and the contract rate. Now, in provider groups, that's a huge deal. Billing and contract rates have almost no relationship whatsoever to each other. Y'all's contracts are percentages. Now, again, nothing wrong with a 23% differential or a 35% differential, or the two contracts I think I've seen. There's a gap, but it's that penalty gap. That's where the penalty comes up. So basically, the way the penalties work, depending upon whether it was late paid or not paid, is it's the amount owed, the contracted rate, plus the penalty. That's that percentage of the amount between billed and contracted, less what was paid, times 18% interest. 18%. So it is a dynamic damage model when you can get it to work right. But unfortunately, it only applies to fully insured claims. So when we started down this road, it was actually through legislative connections that I got the call, because they had seen me testifying against rolling back those provisions. And the first question I asked was, well, that's great, but what are your claims fully insured, or are they self-funded? And what I've been told, and certainly what I hope bears out, is that the majority, if not an overwhelming majority, of the claims are fully insured. Again, I think that might be because the claims are coming in from other places. They're being solicited in, and there's some process that has been used to screen those claims, and that's why I think there may be a higher percentage of fully insured claims in your population than I might otherwise expect. But if you've got 50% fully insured claims, I'm more than happy to take that group on and see if we can't use that to leverage a complete resolution. In the non-fully insured claims, self-funded claims, you've got ERISA. I mean, basically, you've accepted payment, you're under ERISA. ERISA does not have the nullification language, so therefore you are bound by your contract. You have to have very specific assignment of benefits, because you now stand in the shoes of the patient. If you don't have a federally complying assignment of benefit clause, then you are not, for purposes of the law, the patient, and that's who you have to be to enforce your rights against the plan. And so those are the things that we would look at on your self-funded claims. But really, the opportunity here, assuming it exists, is to take those fully insured claims and use them as the leverage tool to resolve the problem. So, I'm happy to keep talking about prompt pay. I'm happy to talk about my firm. I don't know what your data looks like yet. Haven't seen that, so I got no idea what we really have to work with here. But the number one thing is, and this is particularly with Blue Cross Blue Shield, you have well, you do. Actually, y'all particularly do, I'm sure. I literally would spend the first 6+ months, 9 months, battling Blue Cross Blue Shield in front of the arbitrator over who are the claims. Because Blue Cross Blue Shield takes the position in every case that if you can't connect your claim to the Blue Cross Blue Shield DCN number, then we don't know. How can we can't tell you. We don't know if that's the right person. You can be sharing that information with us, because they just don't know. Now, that's beside the point that on their website, they tell doctors exactly how they can do that, because you have name of the patient, date of service, date of birth, and policy. If you have those 4 things, that's what they tell a doctor you have to have for us to identify the claims. And it would still take me 6 to 9 months just to get that out. So, first thing I keep my fingers crossed about here is that y'all will have better information, and y'all will know what the DCN numbers are for the claims. Because if I have DCN numbers, we can get to going on this. The second thing is self-funded versus fully insured. I gotta know the answer to that. Now, I have 3 other pages of stuff that I have to have. I have to know about your systems, about how you store information, about how you respond to requests for information, whether or not you get deficiency notices, you know, how you've communicated about the appeal process, both individually and bulk. Those are all things that I'm happy to work with y'all on. But the 2 most important questions are, do you know the DCN numbers of your claims, and do you know who's fully insured? If you can tell me that, then we can get after this. And my first, as we talked about at the deal, my recommendation would be, step 1, go to mediation. It doesn't take that long. You know, it's a 60-day period of time once we have our information ready. Under my contract, it's at a 25% fee rate, so it's a lower cost if I don't have to file the arbitration. I'm not holding out any real hope, but it's there contractually. I don't think it hurts you to do it. I don't think it slows the process down, and maybe we get lucky. And Blue Cross Blue Shield fundamentally recognizes that they got a problem. And what I want to see in a mediator is I want to see a mediator who knows about this industry, who knows about prompt pay laws. And so when I go and I say there are 4 things, and they didn't do either of those 4 things, I don't care what the excuses are. I don't care what you think they are. You think there's fraud. Great. You know what? Paragraph X, page 7 says fraud. You can terminate or suspend the contract. Did you do that? No. Great. Then those 4 things control. And I'm hoping somebody who actually understands this from a mediator standpoint will then look at Blue Cross Blue Shield and say, okay, guys, what's your answer? Because if the answer is you're done. The only issue, and you won't get a suspended the agreement, those options are all there. I think that would all be very compelling to the arbitrator to say, whoa, no, we don't talk about that because, see, they provided for that right here and they didn't exercise that option. They didn't do it. You got to live with, you know, on one hand, you got to live with the contract to a certain extent. On the other hand, there's only 4 things they can do.
We get into mediation or arbitration and they start coming up with, let's say, excuses or defenses or something like that. It seems like you just simply ask them, did you tell Glen Rose that that was a problem, that you bring it up at all, because they haven't. If they had a defense, they would have hit us with it a long time ago.
Yeah, that's the thing I do after I do this.
Yeah.
Again, this is the thing about the 4. It just doesn't matter. Whatever their issues are, actually, regardless of their validity, the prompt pay laws just don't give you but 4 choices. Under your contract, if they didn't want to do one of those 4 things, they should have suspended you. They should have suspended your contract or terminated it. I mean, that's legitimately what their options were. Do one of the 4 or suspend. Now, even if they do that, they still have a problem because your termination provision still says the claims previously submitted are governed by the contract. So they don't get out of it, but they could have stopped you from keeping doing it, right?
Well, they've effectively stopped us by not paying.
Which, again, is retaliatory.
Exactly.
And you have an anti-retaliation provision in your contract. There's multiple provisions under the prompt pay laws. I never really had a provider situation that I thought qualified as retaliatory, but if they put you on a payment lockout, if that payment lockout extends to non-laboratory claims, if they have put you on 100% billing request, medical records requests, those are,
you got 3.
Yeah, I mean those are nothing but retaliation for this event. That's all that to me that's cut and dry. The idea, and I think even an arbitrator, the most offensive would be the fact that they put your non-laboratory services on payment lockout as well. I think that's almost black letter retaliation.
Michael can tell you that.
Yeah. So now, honestly, I've never had a case that had what I thought was a legitimate retaliatory action to it. I was in the car coming down here, I was actually going into the internet trying to, okay, what is the penalty for that? I mean, I know where their provisions are, and I know the provisions are in 1301. And it says you shall not. But it doesn't tell you what happens to them if they do. I got to go figure that out because I've never had a case where I thought I could make that argument. In this case, I think it's absolutely an argument. And the fact that, again, I don't think y'all have gone as far with TDI as Knox did, but, and look, I hate TDI, to be honest with you. They are some of my least favorite people. They are worthless as it gets.
I do now.
Huh?
I do now.
Yeah, see, and, you know, but the idea that they took the position that this was a contract dispute, and they don't involve themselves in contract disputes, is ludicrous. The law says you cannot contract around the laws. Therefore, apply the rule of four rules. Did they do those four things? One of those four things? No. Hold them responsible. I don't care. Other than the fact that they're complete sellouts to the insurance industry. But that's just my opinion. There's only been one time that TDI has been your firm, and that was between 1999 and 2003. Between 1999 and 2003, TDI was actually had a different commissioner. Forgot his name now, but he was actually a pretty decent guy. But more importantly, y'all may, I don't know how, I'm sure many of you were involved in the health industry at that time. But what ultimately resulted in the prompt pay laws was a coordinated effort between THA and TMA and TDI for hospitals and doctors to file complaints. Complaint after complaint after complaint after complaint. Hundreds and hundreds and thousands. In a span of less than 2.5 years, they penalized the insurance industry over $100 million. Texas TDI did. That was the record that was created heading into the 2001 legislative session, the 2003 legislative session, which resulted in the prompt pay laws. Now, when we were arguing to try to save the prompt pay laws, the exact opposite argument got used against us. TDI comes forward and says, "Well, we don't get any complaints. There can't be a problem because we don't get any complaints." And then my response was, "I'm sorry, how many claims are self-funded?" "Oh, I don't know, about 90%. And I'm sorry, do you actually even recognize self-funded complaints? "No." "Okay, great. So all the complaints on self-funded claims you don't look at, period." So.
All right. If there's nothing further from the board, I'll open the
You want to stay, or you?
Oh, no, I've been on the road for 3 days. I'm going to go home so that I'm in less trouble than I am if I stay. Thank y'all very much. Very much appreciate it. I look forward to working with y'all. Thank you.
I hope you have a driver.
I do, but he's taking me to Granbury Regional Airport.
Well, I know, but you're not getting on the internet. I know.
Oh, yeah. Actually, no, I didn't. In fact, I wasn't sure. I don't mean to. This is my first inaugural trip to Glenroe. I wasn't sure if you had Uber or taxis. Beaumont didn't have taxis until like the 2000s. And we didn't have Uber until, probably about 5 years ago, 4 years ago. So anyway, so I'm not sure whether there was Ubers or taxis here. So yes, I got a driver in a car to bring me down here, stay around while I was here, and then take me to the airport and get off. So thank y'all very much.
Good. So, thank you, find the elevator. Thank you very much. You're there for me. Good.
Thank you.
All right, do I have a motion on this item?
I will make the motion to authorize our chairman and CEO to work with our attorney to negotiate a client representation agreement with ProvstUmphrey law firm for the purposes of settling our Blue Cross Blue Shield dispute.
Excellent. Motion by Dr. Vossick, second by Brett Neighbors. Any further discussion? If not, all in favor, you will sign for. Oh, thank you. Tomorrow. Well, yeah, obviously it's going to take a while, and Kevin's going to have to walk us through all of the hoops that we have to jump through to get this done. So it's going to take a little while.
We'll be contacted tomorrow.
Yeah, contact him tomorrow. Let him know that.
I would say I found his presentation very enlightening and helpful.
I think he knows what he's doing. Okay, did you want to go back on anything on CEO part, Ray, or go forward? We okay?
Lab outsourced, we're not taking any samples.
Okay.